in an active case when the employer has already been found by the NLRB to have openly violated federal law. It gives that employer a legislative pardon. It destroys the very concept of equal justice before the law and equal protection of the law. It is an attack on the First Amendment rights of workers to free speech, and it destroys their right to a legal remedy. It has constitutional questions that involve the Fifth and the 14th Amendment. It tramples on the rights of workers who, consistent with their rights under the National Labor Relations Act, have legally protected rights to strike, and they're punished for it, punished by having their jobs moved out of their state. Now, this legislation doesn't just pit workers in South Carolina against workers in Washington State and pit our colleagues against each other, but it pits the Congress against all workers by essentially striking any remedy for egregious violations. This legislation undermines the rights of American workers to defend their right to organize, to defend their right to collective bargaining, to defend their right to strike, to defend their right to decent wages and benefits, to defend their right to a retirement, to defend their right to a safe workplace. It diminishes the standing of all workers. It's a bill that's bad for business because the essential relationship of cooperation, which is needed in our economy between business and labor, is destroyed. By stopping a remedy, it accelerates an adversary relationship. It sets a precedent for Congress to intervene in other regulatory matters of this sort. We wouldn't be here if Boeing had not violated the National Labor Relations Act and punished its workers for lawful, protected activity. The punishment the workers received was moving jobs from one area of the country to another. This bill represents an extraordinary intervention in an ongoing legal process where the defendant, Boeing, is not seeking, we have to ask, is Boeing seeking this? Is Boeing seeking this legislative pardon for its violation of the law? Boeing workers had only 3 strikes in 20 years, and on issues of great consequence, health care benefits, pension benefits. One strike was because they wanted to spend more time with their families on weekends. They didn't want to be forced to work on weekends. Let's talk about family values here. We know that Boeing executives have said that moving the Dreamliner to South Carolina was due to strikes happening every 3 to 4 years, that the decision was made in order to reduce Boeing's vulnerability to disrupt delivery disruptions caused by work stoppages. That's bogus. This was caused by mismanagement of the 787 project, where the Dreamliner was subject to a vendor system that was spread around the globe because of vendor system that was out of control, because of poor quality controls within that vendor system, because of parts that didn't fit, and the U.S. workers didn't have anything to do with it. This is management scapegoating the workers in order to try to duck questions by their investors. I mean, we really have to look at what we're doing here. Boeing has wanted to put the blame on its workers for delay in development of this Dreamliner. This is a questioning of Boeing's management, and I have to say that, you know, this Congress should want Boeing to succeed, but not by undermining its workforce, which is the best in the world. We need an American first manufacturing policy where the maintenance of aerospace, steel, automotive, shipping is deemed to be vital to our national security. And we need to protect America's workers along with that by protecting their basic rights through enforcement of the National Labor Relations Act. This law devastates their right of recovery. We should be concerned about protecting American jobs, protecting America's basic industries, protecting America's basic workers. We should be concerned about taking a stand for America on this, and I say that this legislation isn't mindful of that, and we need to strike it down. Thank you.